the leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacked voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. My guest in this podcast is Professor Ali Orr Larson from the William & Mary Law School, where she teaches a rather unique and specialized area of law, which has to do with fact-finding in the American judicial process. And you may think that's a really boring topic, Sheldon. Why are we talking about it? The reason we're talking about it is because of the way the Supreme Court has recently behaved with its fact-finding. And the professor and I are going to explore how the fact-finding processes in the judiciary have been abused by the Supreme Court and how that fact-finding mess that they have made has contributed to them blowing over precedents and making decisions in the interests of what I contend are their big donors and supporters from the far right wing. So, Professor Larson, welcome to the podcast. I'm delighted to have you.
Oh, thank you for inviting me. I'm happy to be here.
There is probably no better expert on this fact-finding question than yourself. You've written multiple law review articles about this problem. If we look back, there really hasn't been much academic work about the problem of false fact-finding at the appellate level in the American judicial system, which I guess probably was the case because there wasn't much false fact-finding being done at the appellate level in the American judicial system. But now you have to write about it. Professors Blocher and Garrett in the Duke Law Journal have written about it, and I've written about it. What's behind this new concern about appellate fact-finding?
I think that in some ways, courts have always found facts on the fly, or appellate courts finding facts that aren't tethered to the record. That happens occasionally, but we've seen a real acceleration, I think, due to technological change. So the way that we all access facts, and that includes judges, has really radically changed since the digital age. And that is what I think is behind this new hunger for empirical information and historical information and social science data and hard science data, and you name it. The way we frame legal arguments, it's expected to be steeped in that sort of information now. So it becomes really critical to think about where that information comes from and how we know whether it's reliable or not.
Now, the baseline of all of this is that information comes in at the trial court level. And because it's coming in at the trial court level, it's subject to several tests. One party has to put it in, which means the other party gets to argue about it. So if there's questions about what facts are true, that fight gets fought out in the court. And a neutral judge then makes the decision. So there's some safeguards built into that process that keep false facts out of the judicial record. And should the judge get it wrong, then you've got the next level of appeal where a really egregious factual error can be overturned. What is the value, in your view, of that tradition in American law, that facts are found at the trial court level, not on appeal?
I think it's tremendously valuable. It's a safety net, if you will, that undergirds our entire system. I mean, surely it's not perfect, but the idea is when you have two sides adverse to each other, fighting it out, that they'll be able to poke holes in one another's factual case. And then you have a system where the trial court evaluates the experts, if there's expert witnesses, and thinks about the different peer-reviewed journals, and then makes a decision, and that decision is then appealed, but with deference to the trial court's ruling. Now, you recognize this in your article, but there's a distinction in our system between facts that typically go to trial, which what you're called adjudicative facts. I think of those as like the whodunit kind of facts, like who did what, when, where.
Yeah.
And then on the other side, we have what are called legislative facts, which are more generalized facts about the way the world works. And those are the facts that you and I are writing about. And those are the facts that are completely unregulated in terms of how they proceed through the court system. So they can come through trial, but they don't have to. They can come up at the appeals court. They can come up at the US Supreme Court. They can come through the parties. They can come from amici. They can just come from the judge's own internet research. There's no rules about it. And I think that's led to this wild, wild west of appellate fact finding.
Although the custom is that they still come in through the trial court. They may be the subject of expert testimony, and they may be embedded in the judge's decision as kind of an implicit presumption about the way the world works. But the node through which the factual baseline of a case comes is ordinarily the trial court.
I mean, that is the traditional way we think about facts, but there's no rule prohibiting these legislative facts from coming in at the appellate level. I think what's happened is, as we've gotten more hungry for that sort of fact, and there's very little procedural safeguards about how they're introduced and when they're introduced, that's how we get to this mess. That's how we get to this world in which you have appellate courts finding facts from amicus briefs and other even less reliable sources.
Yeah. Since you mentioned amicus briefs, let's talk about those just for 1 second. Amicus briefs are briefs that are filed by interests that are not a party to the case. They're usually filed only at the appellate or Supreme Court level. And they're an opportunity for people who care about the outcome in a case to offer their views for the court in a formal fashion, but they're not tested by adversarial process. They all just come in, and then the court reads them. And then at the end of the day, when the court writes its decision, it may or may not decide to use the amicus briefs, quote from the amicus briefs, believe the amicus briefs. It's kind of a black hole until the court renders its decision.
Yep, that's exactly right. And these briefs come in sometimes at the very end of litigation. So one thing that's important to realize is not only is it immune from any sort of adversarial check at the trial level, but even the Supreme Court advocates are left in a bit of a bind because they can't possibly respond to all of the amicus briefs. And then if they want to respond to one that they think is false, that risks drawing the court's attention to it. So there's sort of a litigation strategy that they don't really want to draw the court's attention to these briefs. And that means there's a very feeble check, if anything, on the reliability of the factual assertions made in those briefs.
So if you don't mind, let me ask you to think about two very prominent Supreme Court cases in which I assert that false fact-finding took place in a way that was essential to the outcome that the court wished to achieve. The first is Citizens United, and in my estimation, the false fact in Citizens United is all of this unlimited money that we are allowing to flood into our political system will come in transparently, and voters will know who is doing the spending and can evaluate the motive of the spender accordingly. That has been proven fabulously false by billions of dark money dollars that have flowed in, but the court has never gone back and corrected its error. In Shelby County, the false fact was the finding that the bad old days of Southern legislatures trying to take the vote away from minorities or inhibit the voting by minorities is all over. We don't have to worry about that any longer. This is a new day. And then, of course, instantly the Southern legislatures responded by passing a whole slew of new laws targeting minority voters. And despite that history, the court has never gone back to say, oops, maybe we were wrong about that. Does my description of those two cases and the factual error in them ring true to you? And when it happens at the Supreme Court level, where do you go to complain about a false fact?
Yeah, there's not much that can be done when you're talking about a constitutional decision. But so what is happening in those two cases in particular, in my judgment, is this unhealthy blending of legal claims and factual claims. And I don't think it's confusion. I think it's more deliberate. So I think there's a faux modesty about making a decision that sounds factual. So in Citizens United, for example, the way the court talks, it's full of factual rhetoric. They're talking about scant evidence in the record. And so then they want to say, well, no, this was a legal holding, not a factual one. And that means it's ours to decide. But they're kind of having it both ways. Like they're hiding in the factual rhetoric, even if then they want to say what they're making is a legal conclusion. And so I think that's an unhealthy confusion, an unhealthy blurring of the line between fact and law. In terms of what can be done, well, once you say that this is a legal conclusion and an interpretation of the Constitution, it's not something that can easily be undone. The court would have to take the issue up again and reevaluate their sort of assessment of the factual landscape. That's very unlikely to happen. Maybe they were false at the time they were made, but even if they weren't, facts change. And so you end up with a stale understanding of the way the world works that's protected by a legal precedent. And that's a very unhealthy place to be.
It could have been an innocent error by the justices, but if it had been an innocent error of fact, then when it was pointed out that it's actually indisputably false, and here are all the post hoc pieces of evidence that prove that, you'd think that if they were being honest about it, they'd want to go back and clean it up and fix it. And I'll tell you a quick story, which is that when the Montana case came in, after Citizens United, the Bullock case, I wrote a brief to the Supreme Court saying exactly that. You guys got it wrong, both about this money was supposed to be spent independently and this money was supposed to be spent transparently. Independently, it's a little bit more complicated. Transparent, obviously wrong, indisputably, totally plain. All this dark money proves it. And the co-signer of my brief was John McCain. So it was a bipartisan brief. It was by Senator McCain, who was an expert in campaign finance, and it pointed out an indisputable error that the Supreme Court had made, and they refused even to allow argument. They just threw out the Montana case on the grounds of Citizens United, notwithstanding that this brief had pointed out their error to them. So when you say that sometimes this is deliberate, that certainly is the conclusion that I drew from the Supreme Court paying no attention to an undisputable fact problem.
I mean, that Montana case is so interesting because in Montana, they read Citizens United as being a case about a factual record. And they said, well, things are different here in Montana. And so when the Supreme Court summarily reversed, it was basically, we might have been talking in factual language, but actually this is a question of law. And now you just have to do what we say because it's a legal precedent. And that seems a little bit unfair, like you're trying to have your cake and eat it too.
Most of these factual errors lean in the direction of the decision the judges want. In some cases, the decision could not have been rendered legally were it not for the false factual predicate embedded in the analysis. So they simply couldn't have gotten where they wanted to go without the false fact. And it's a tell to me of a court that is deliberately trying to change the law in certain ways, even if they have to invent false facts in order to get the outcome they wish to achieve.
I mean, I think it's like the same infection that's plaguing all of us, which is you see the world the way that confirms your prior worldview. So you observe facts and you make a factual record in your own head that's convenient to you. So even if they think that they're seeing the world in a clear-eyed way, they have to be subject to confirmation bias and echo chambers. And that's a danger in really anchoring these legal claims in factual assertions at all.
Yeah, which brings us back to the fake flotillas of amici who come in and file their amicus briefs and provide that echo chamber. Recently, the court has moved into a new standard for deciding constitutional cases. It used to use what we'd refer to as a balancing of the interests standard. How important is the government's interest? How important is this particular private interest? And how much harm will there be to those interests? And what's the best outcome? They jettisoned that and moved to what they call the history and tradition test. It strikes me that you can do a lot of false fact-finding around history and tradition if you want to, and that switch in the legal test opens up whole new arenas for fact-finding mischief. What do you think?
Absolutely. I think that's completely right. And, it's really important to know where they're getting their history from. I mean, this is where the amicus briefs has a lot of bite, because they're not like going to the library necessarily and reading the whole history of what the founding generation thought about firearms. No, they're taking the history that's provided to them from these motivated advocacy groups. And that's an odd way to do history. That's certainly not the way historians think of their work. It's what Justice Breyer called law office history, which is not a flattering term. And that means using history to make a point instead of looking at the contextual nature of some things cut one way, some things cut another. And that is just a feature of this type of constitutional decision making. Like, once you say, I want to look at history and tradition as the way to make these decisions, you're inviting that law office history, and you're almost destined to have a skewed account, and probably a faulty one. So I think we're at the beginning of a real kettle of worms, as my dad would say.
Well, the good news is, at my request, the Judicial Conference, which is the administrative body that runs the judicial branch, is taking another look at what reporting is required when entities come in and file amicus briefs of who really funded them and who they're related to and so forth. We've had briefs filed by an entity that isn't even real. It's the fictitious name under Virginia corporate law of a different entity, and they didn't even disclose that in their filing. So I think there's a lot of cleanup work to do that I hope the Judicial Conference will be very diligent about, because it's important to look behind the screen of who these phony baloney amici are. It's not the American Medical Association or, the Highway Contractors of America or the Association of University Presidents. It's these groups that have been sort of pop-up invented to obscure who's behind them, and that's kind of it.
And they all have neutrally sounding names too. So it's not easy. You think of a law clerk, it's not always easy to tell who is really paying for that history or who is really paying for that advocacy. So I think disclosure rules are well overdue and very important. I'm happy that you're working so hard on that.
Yeah, and the Judicial Conference has said that they're going to fix it, so we'll hope that they go about it diligently. Tell me a little bit about the difference between what lawyers would call a factual precedent versus a legal precedent.
A legal precedent is when you have a principle established in one case that then is used as authority in a subsequent case. So we're all sort of familiar with that. A factual precedent is a phrase that I coined about a decade ago. It's when the lower court relies on a Supreme Court assertion of fact as authority that observation is in fact true. So my favorite example here is Justice O'Connor had written in a case that carpal tunnel syndrome resolves on its own without surgery. And she was just writing that in her rhetoric, in her case explanation. And then a bunch of lower courts just started citing that, like Justice O'Connor as the authority for carpal tunnel. And she was a wonderful jurist, but she was not an authority on carpal tunnel, nor did she think she was. So I'm sure she would be very surprised to hear that her words on that have been used as authority in lower courts. But the more the Supreme Court says about generalized factual assertions and how the world works, then it's inevitable reality that the lower courts will cite the Supreme Court as a precedent on those factual claims. One scary effect of the increased fact finding is the injection of falsity into Supreme Court decisions. That's bad enough. But I actually think the downstream effect, how tomorrow's cases are decided in reliance on the Supreme Court's statements of fact, that's perhaps an even scarier reality.
So Marbury versus Madison is the legendary case that every law student learns immediately, in which the Chief Justice asserted that it is emphatically the province and duty of the judicial branch to determine what the law is. There is no such authority to say that it is the province of the judicial branch to decide what the facts are. How should we work our way through the Marbury v. Madison judicial supremacy with respect to the law versus this factual precedent thread that is creeping into adjudications?
You write about this in your article. There's a difference between appellate fact-finding in the abstract or appellate fact-finding where there's no legislative record. That's one problem. We can talk about that. But there's an entirely separate problem in Shelby County, in Citizens United, where you have a congressional record, a co-equal branch of government that's put together their own account of the facts. In that situation, it is very difficult to adhere to judicial humility and judicial modesty if you're going to second guess the fact finding that comes from a co-equal branch of government. So to me, that seems like the easiest case maybe for judges standing down is when you have a bipartisan congressional record that was established over a long period of time and to support legislation. If you ignore those facts, I mean, where are we then?
So let's say you need to answer that question, where are we then, and you're a member of Congress. Or let's say you're a district judge hearing a case that relates to Citizens United, and you're presented with a legal precedent that stands on a false factual precedent that you now know to be false, and you're stuck with it. What are some of the tools or ideas that you think would be helpful to either members of Congress or lower court judges when they're presented with a false factual precedent?
After the fact, there's not very many tools. Maybe thinking ahead to the next wave of legislation and litigation, there are things that Congress can do in the statutes that it legislates. So this is what Joseph and Brandon have written about, coming up with standards of review and specifying what those standards of review are to be. I think you can take proactive steps looking forward to perhaps guide the factual inquiry from the courts once it's litigated. Looking backwards, honestly, it's very difficult when the decision is constitutional. There's just not that much that Congress can do at that point, which explains why it's so important to get it right the first time.
Well, I hope that you and your fellow law professors in the academic world continue to dig at this and help us to find our way through the problem. I guess I would say that yeah, I would say I regret a little bit that your work has become so topical, because the topicality of it has a lot to do with the Supreme Court that is willing to engage in false fact-finding at the very end of the process when there's nobody left to correct it and make false fact-finding conclusions and determinations that get them where they want to go but actually aren't real. And that is a problem that we're going to have to live with. And it signals to me that this is a part of making the case that this is a Supreme Court that has gone a little bit off its rails. And without asking Professor Larson to comment on that, let me thank her for bringing her expertise into this conversation. And much appreciate having you on, Professor.
Well, it was a pleasure to be here, and I think your article is wonderful. So it was required reading.
Oh, good. For those listening, it will be out shortly or maybe out already in the Ohio State Law Review. Thank you all, and appreciate your joining me as I make the case.
Thank you, Senator.
balance as a or two, and we'd